Hello cybersecurity skills class, and welcome to this next video lecture. In this lecture we're going to talk about cybersecurity compliance tools and compliance frameworks. Let's talk a little bit first about compliance frameworks, and in particular we're interested in the legal and policy framework that prompts us to be concerned about cybersecurity compliance. So I asked you this week to read Executive Order 13636, as well as some information from the NIST Framework. Now, if you took the Internet Law class, you'll know that Congress has been trying for a number of years to adopt some kind of comprehensive cybersecurity compliance scheme, but has not been successful in doing that, and it doesn't look like that's going to happen anytime in the near future. So in the absence of congressional action, and not without some degree of controversy, President Obama issued an executive order, that's 13636, that outlines at least some kind of basic minimum recommended approaches to cybersecurity compliance for critical information infrastructure. And you'll see as you read through that order that the thing that's primarily recommended is the National Institute of Standards and Technology's cybersecurity framework. And we're going to talk in just a minute about what that framework looks like and what it contains. There are, in some specific regulated industries, some particular rules and guidance documents. We're not going to dive into them in detail in this class, but you ought to be aware of them. So for example, you're probably aware of HIPAA in the healthcare realm and high tech in the healthcare realm, and these are statutes which set up rules which provide for covered medical information, rules about privacy and security and disclosure, and they include cybersecurity rules. In the financial services industry, there are a couple of applicable areas you'd want to think about. The Gramm-Leach-Bliley Act has specific rules about cybersecurity and encryption of certain kind of data. The Securities and Exchange Commission has issued guidance documents that recommend what kinds of disclosures should be made in annual reports with respect to cybersecurity incidents, as well as recommendations for entities that are licensed and regulated by the SEC, such as broker-dealers. FINRA, another one of the major financial regulators, has issued guidance documents about cybersecurity as well. And there are some others, for example, at the state level in New York, there's some proposed regulations that actually are pretty strict and would cover quite a lot of financial service businesses, because so many of them are located in New York City. So just be aware that financial as well as healthcare is an area where there's some particular regulation. Also in the energy sector, the Department of Energy has issued guidance documents over the past year or so, which cover power plants and things like that. Again, these are guidance documents. They're not regulations, so there isn't a specific legal duty, but presumably these guidance documents set out at least some kind of minimum kind of duty of care or reasonableness duty. The Federal Trade Commission, as all of you know, is also actively engaged in enforcement in this area. The primary role so far of the FTC is to try to ensure that companies are following their own published privacy policies, and the FTC pursues claims like that under the general provisions of the FTC Act, and claiming that it's an unfair trade practice to not follow your own privacy policies. And you all are also all aware of state data breach notification laws. So pretty much every state in the United States has its own set of laws about who has to be notified and how they have to be notified and when they have to be notified in the event of a data breach. A handful of those provide a private cause of action. Most of them don't. It's a regulatory obligation, and it doesn't impose any cybersecurity requirement on the front end. It does provide that, or many of those statutes provide that you don't have to give notice if you've encrypted, so it encourages encryption, or at least some of those statutes. encourage encryption, but there are notification statutes on the back end. So all of these things are potential drivers of cybersecurity compliance procedures and policies within an organization. These are all reasons. Certainly if you're one of the regulated industries in those particular sectors, you're going to have a particular reason. But even if you're not in one of those particular sectors, you're going to at least have some incentive to think about whether you might fall within the terms of the executive order, or whether you might be putting out a privacy policy that you have to comply with, or the cost of notifying in the event there's a breach. I think even more significantly, or at least as significant in terms of risk, is the risk of litigation in the event that there is a breach. And you all know, and we've had people talk about in class, the various kind of state and federal class action litigations brought by consumers for breach of credit card data, like the Target breach you've heard talked about a number of times in class, and so on. Now, it's an interesting kind of risk because a lot of these cases have been dismissed at the pleading stage for lack of standing, for lack of cognizable harm, because credit card consumers generally are reimbursed by the credit card company. We are seeing, I think, a bit of a trend, certainly in the Seventh Circuit. There is an important case that says that a consumer can have standing in this kind of case, and even just yesterday, in the P.F. Chang data breach, which had been dismissed by the trial court, the Seventh Circuit reinstated it. So, you're seeing some of these cases get reinstated. A lot of these cases, even if you have to get through litigating, at the pleading stage, and even if you succeed and then you get it goes up to the circuit and you succeed there's still an enormous amount of expense. And there's an enormous amount of sort of lack of clarity in the law. That lack of clarity creates a significant liability and a significant risk. Executives in organizations, as you heard Erez Lieberman, for example, talk about, are very, very concerned about this, because you've seen cases where people have, high-level executives have lost their jobs because of the bad publicity and the costs of data breaches. The bad publicity, by the way, is also a significant cost. If you're a publicly traded company, it can hit your stock value, and you can lose millions and millions of dollars of stock value in a day because of bad publicity. So all of these things, and really this threat of these kind of general regulatory or soft regulatory requirements, coupled with the mitigation costs, the business losses, stock market losses, and the potential threat of litigation, provide a really strong incentive for most organizations today to be thinking really seriously about cybersecurity compliance. So, what is a proper cybersecurity compliance program? I think one of the interesting things about this field is nobody really knows for sure, and it's going to vary potentially even significantly across different kinds of businesses. But there are some principles we can think about, some compliance principles we can think about that are common to compliance efforts, that in many ways, as you think about them and as we look at them now, you'll see they're really kind of common sense. But what they do is they make the relevant people in an organization slow down and think carefully through these different elements, and to work carefully through a compliance program that is hopefully a little bit proactive and prophylactic rather than just reactive. Having said that, everyone you talk to in this field will say you can do all the proactive, prophylactic work that you can, but it doesn't mean you're ever going to have perfect security. As we've seen, the hackers are really good. So you not only need to try and prevent it, but you need to be ready to mitigate it, and when it happens, and we'll talk about that as well.